Thank you.
SJC-10942, Commonwealth versus Roy.
Thank you.
Good morning, Your Honors. My name is Charles Stevenson. I represent the defendant, Robert Roy. Apologies at the outset. This record is one of the most unwieldy with which I have dealt in my lifetime, both in terms of its sheer volume, but also the imprecision of the testimony that characterized really both the government's and the defendant's case. It was tried in 2010. The underlying incident occurred in March of 1986. To put that in perspective, 3 events from that year, the Challenger tragedy, Chernobyl, and Bill Buckner.
In that order? Or?
Well, actually it was in that order, but perhaps not in order of importance. In any event, we really have to dust off some synapses, I think.
This seems to be our morning for that. The case
It does, I guess. But this was a different case, and one that doesn't involve the question of a speedy trial, because in fact, and it should be noted, Mr. Roy was at liberty for a considerable part of that 24 years. But because memory was such an issue, and all of the sort of collateral effects of memory over the years, vagueness, confusion, prior recollection recorded, all of those things seem to play a particularly large part. And I think as its handmaiden, this case really hinges on the question of what is or is not a reasonable inference. And it is, after all, the all-purpose judicial expression. Reasonable doubt, reasonable instruction, whatever it is. In the context of inferences, though, it seems to me to be something that is uniquely and totally personal. And perhaps it's my perspective, perhaps it's hardwired in my DNA, but I think I see differences. I see differences between this court's interpretation of what's reasonable and perhaps what I do. Certainly, and I apologize, it's too bad that Ms. Zelnick and I can't agree more fully on what the facts are. But that's, of course, where the communication breaks down. We can agree, though, that at the end of this case, there really was no question about who the perpetrator was. The defense was appropriately put the government to its proof, but there was compelling evidence that Robert Roy was the perpetrator. So the questions then become, did he have a fair trial, and what, in fact, was the grade of homicide that he committed? Further complicating this immense record is the fact that I make a series of arguments which depend on different standards of review and different manner in which the court must review what the evidence was. There's sufficiency arguments, there's weight arguments, and there are those arguments which hinge on reasonable alternatives that the jury could have had they been properly instructed in this issue or that issue. There are, however, some common threads, and I want to emphasize that, in my view, most of the evidence raises more questions than it does provide answers, and that, of course, is one of the reasons why I've provided that map this morning. It was Exhibit 79 at the trial court, and the area to the upper left is where this incident was alleged to
Holding
have
it
occurred.
vertically or horizontally?
Oh, I'm sorry. Let's see. How would that be?
Horizontally.
Horizontally.
Okay.
The area is between Guillotte Street on the south and Main Street on the north. This is in the town of Acushnet. Point out, though, that these three little lanes there, Honora, Shade Tree, and Buttonwood, did not exist then. So we're talking about this area in that quadrant.
But if Saucier Street, Main Street, and Guillotte Street are the boundaries?
Yes. And parenthetically also, the victim, Marnie Roy, lived with her family on Slocum Street, which is down at the bottom. Mr. Roy was, at least his family lived, though he did not at the time, on Nye Avenue up almost at Main Street. Just as a little aside, there's a parking lot you can see along River Street. That happens to be where people used to park when they went to work to make golf balls, because just off the map to the south is the Titleist factory, which is now defunct. But it was a leading industry in the town of Acushnet for a number of years. In any event, unsurprisingly, one of my gravest concerns is with the verdict as to first-degree murder, extreme atrocity. And reflecting my biases, I would suggest that this case is yet another illustration of the largely standardless definition of what is extreme atrocity. I know there are 7 factors. I know those 7 factors have been written about ad nauseum. I know this jury was instructed. But I would suggest, really, I think there's an old expression that occurred to me this morning, tyranny of lists. Is there such, am I right, that's a term? In any event, this list is one which seems to have assumed a life of its own, and which, if closely examined, is rife with inconsistencies, with actual conflicts. It's simultaneously too broad and too narrow because, of course, there is no provision made for considering extenuating or other kinds of circumstances which might reduce, in the jury's view, a defendant's culpability. In any event, there are.
Was deliberate premeditation offered and not answered by the jury?
Yes, it's actually in the appendix. I put in the verdict slip. So they had the 2 choices and chose only extreme atrocity. One of the disputes that I have with the government is whether these various causes of death about which Mr. Roy either made admissions or the medical examiner opined, whether they are, in fact, mutually exclusive or, as the government suggests, all part of this great big package. We have the Donna DaCosta testimony that Mr. Roy came over and started pounding Budweisers, and then just spontaneously, in response to some comments she made about she wished that her husband were dead, told her this story punctuated with pounding his fist, that he'd found his wife at a house party, had flipped out, had dragged her out of the house, had yelled at her, that she had said, "I just want to go home, I just want to go home," and then he'd put her in a car, driven to the woods, pulled her out, stuck her on a chair that he'd kept in the car, tied her up, and taped her, and then threw her in the bottomless pit. Okay, so I call that the drowning scenario, notwithstanding the fact, of course, that this happened in broad daylight, that there was no house party at that time, and that it seems somewhat unlikely in this area that you see there that somebody would have been driving around a car with a rope and carpet in it, or excuse me, not carpet yet, that comes later, with rope and a chair. So then there's the second scenario offered by the jailhouse informant Hayes, who says that he told him variously saying, I heard this a number of times or I heard it once, but in essence saying, I choked her out and threw her in the, I don't know, where the sun doesn't shine or something to that
for a
effect.
swim.
Pardon me?
Took her
Something
for a swim.
Took her for a swim. Yeah.
So then that's suggesting perhaps a drowning again, but choked her out to me suggests strangulation. Finally, the medical examiner who, and there's some heavy lifting that just really has to be done here by the court, and I apologize, but the medical examiner's testimony is one of those things. And, you know, you'll find that he said, well, it could have been a rock, it could have been a tree, it could have been a log, it could have been the ground, it could have been a blow to her chin and a blow to the back of her head. We do know that she sustained at some point a serious not a laceration.
Fracture.
Pardon me?
Fracture.
Thank you, to her skull, and that ultimately the medical examiner opined that that was
Also broken?
yes. So the blow to the jaw, and there was byplay about, well, could they have been a single incident? Does it matter that Marnie was 5'2" and not 6'5", which he suggested it does make a difference because of the distance she might have fallen, but then ultimately says, geez, I know nothing about the positions of the parties, whether she might have been on an elevated place and fallen against something hard, against something soft. In any event, I won't belabor the argument, which I think I make fairly exhaustively in the brief, except to acknowledge that I'm walking a tightrope here, both in terms of the law and the facts, and that it's a station-to-station tightrope. It's not one where if I fall off here, I can get back up again. That the argument is what it is.
Let me, with that great Belichick comment, tell me, in terms, what is your view as to what the evidence, what's the best version of the evidence that you could present, and would, under that best version, would that support a finding of extreme atrocity?
Well, I would say clearly not, and the best is that the doctor really could not exclude this possibility of a blow either to the back of the head with a fall forward or a blow to the front of the head with a fall backward. He thought it less than likely because both injuries were on the right side of...
But any indication that either of those blows would have caused instant death?
Well, he was all over the map on when unconsciousness and death might have occurred. Anything from saying, well, it could or it could not have caused death. Ultimately, the judge says something to him. We really need that in a medical certainty term. And he says, yes, I'm confident that was the cause of death. But nothing that suggested that it was one of those, it's like premeditation, seconds, minutes, hours, days.
But even with your view, I mean, what does our case law say, that assuming that death was sudden and nearly instantaneous, then taking the body, attaching it to a cinder block, and then dumping it into a gorge, does that not play in the extreme atrocity calculus?
Well, I don't think you can be extremely atrocious to a dead body, and perhaps the court disagrees. Again, I think that one has to at some point impose some standards, a baseline, and I would suggest that that would fall far below it. But because, taking her for a swim, throwing her in the bottomless pit, I mean, those suggest that's how I disposed of this body. And I think it's like consciousness of guilt. Yeah, you can consider that as to whether or not he was the actor, but you really can't use that to determine what his state of mind was at the exact moment that a blow was struck or the strangulation.
But the problem, and I think there's a recent case that I wrote that addresses it, is that, of course, you can't be sure precisely. You may know what the course of events were that the defendant may have done, but, of course, you can't necessarily be sure either when, during the course of those events, the victim died, and whether or not the defendant would have recognized that she was dead during the course of it. So what do we do with that?
Well, I frankly am not sure, but it seems to me that it's a situation where the government ought to bear that risk. I mean, no one should be rewarded for being cruel and atrocious, but by the same token, there really needs to be some specific evidence which establishes something that the jury could then grab a hold of within those 7 factors. It is, I'm sorry.
Finish, I'm sorry.
I was just going to say it really is a philosophical issue and one that we may simply disagree about.
Was there any testimony from the pathologist indicating any breaks to the bones in the throat?
They were all gone.
Okay.
I mean, so it actually came up, and he said, well, it's not inconsistent with strangulation because we don't have anything to look at.
And it wasn't, there was nothing to suggest that I forget the name of the bone, begins with H. Yeah.
Hyoid, yeah, it was gone.
But nothing to suggest that it was gone, that the reason that it was gone based on what was still there was connected to being strangled or anything.
No, I mean, this was a pretty disgusting place where her body was found, and I think a ton of silt and things like that. And, there was no evidence that they had come in and dredged in some way to look for all those little bones. They didn't.
Could the jury have believed that she had been strangled to death, and notwithstanding the doctor's testimony?
Yes, because that's what supposedly Mr. Roy said to the guy in jail.
Huh.
Yeah, so
and that's evidence of extreme atrocity or cruelty.
Well, it is, and that's why I said I was walking the tightrope, because you would have to agree with me that if one of the 3 postulates is insufficient and the jury didn't specify which postulate they were relying on, that, as in Plunkett or one of those kinds of cases, you would have to say, we don't know what they did, and therefore we must give the defendant the benefit of the doubt. With the court's permission, if I may briefly digress, I counted up earlier this week, and this is the 50th presentation I've made in this court. It's also the last. And I wanted to particularly express my appreciation to the clerk and her first assistant for their many kindnesses over the years. We all appreciate it more than I'm sure you could know. And there's always been a sense that lawyers are important to the clerks, not so much because of who we are, but because of who we represent. And so I'm sure the court is very proud of Ms. Mellon, and I'm proud that she's my friend. I wanted to, if I could, conclude with a tale, and it's, I'm sure, one that I could best explain with a bit more time.
Mr. Stevenson, before you do conclude, I'm happy to have you have the last word, but I do want to say that it is our loss that this is your 50th and your last case. But I do have a question for you on page 55.
It is definitely our loss. We would just add.
Thank you.
You say, and you have such a marvelous way with words that I need to ask you, and I'm being shamelessly obtuse about this, but you have this wonderful phrase, arguably the most fragrant misuse of the evidence. And
Does it really say that?
I assume it was a typo.
You don't have to answer this question, because to leave it hanging, I think, would be wonderful. But is that a typo, or did you mean fragrant?
I don't even see it now.
It's the
That-
beginning of the last paragraph on that page.
If this isn't an example of how much I've lost off my fastball.
Well, this could have been a fork ball.
Yeah.
Pretty
Well,
good
you know
one.
what? I don't throw fork balls in court. But in any event, it is a story, and if Your Honor will indulge me, that I think resonates with all of us. It's an appellate lightning in the bottle story about second chances. And it's about a young man named Stephen King, who I first encountered about 17 years ago at the Westboro Detention Center, otherwise known as the DYS facility, or in my terms, a jail. He'd been convicted of having killed his very best friend, who died in his arms, as a consequence of the inadequacies of his trial lawyer. He had been convicted, and with his family, I set out to establish his innocence. We were completely unable to persuade the trial judge of that fact, but 3 courageous and diligent judges in the appeals court agreed with us, and young Stephen was ultimately exonerated. We all know those courthouse stories. We see them, or the courthouse steps. We see them on the news every night. But in this case, I wanted to give you, as Paul Harvey would say, the rest of the story, because that was just a way station in a life that was saved as a result of the appellate process. He has since graduated high school, college, has earned a master's degree in urban planning from Brooklyn College, and is now completing his PhD at University College in Dublin. He's a marvelous young man. He's worked for the Writers Guild and is a writer himself. It's also the story of his older brother, who was a young, about 25-year-old when I first met him, having been born and raised and lived his entire life in the venality and corruption of South Boston in that era. He was an angry, angry young man. But as a consequence of his involvement in the appellate process and ultimately the outcome, I think we let the genie out of the bottle. He's a widely applauded and recognized and honored writer now. And I say this not to congratulate myself. That's not what this is about. It's about, though there's this gulf that separates me from you, I call it the moat. There are times when together we really accomplish some wonderful things, and things that perhaps go unrecognized, but which make our careers and, in fact, our lives worthwhile. So thank you.
Thank you very much.
Thank you.
Good morning, Your Honors. Eva Zelnick for the Commonwealth. This was my brother's 50th, I think he said, and final argument before this court, and my first. So,
He has lifted the level of debate.
he has. I have to think of a good story for the end of my argument. Your Honors, irrespective of what one might think of the extreme atrocity or cruelty standard, the Commonwealth's argument is that if there ever was a case of classic extreme atrocity or cruelty, this is that case. The second argument that
You say that, but how do we, I mean, we don't really know precisely what happened here. We have various versions, perhaps none of them good. But how do we evaluate a case in which there are alternative versions as to what occurred?
Well, Your Honor, that's precisely the issue upon which my brother and I disagree, I think, the most strongly. The premise of my brother's argument, the defendant's argument, that the Commonwealth did not meet its burden to establish extreme atrocity or cruelty in this case, was that the Commonwealth presented the jury with 3 mutually exclusive scenarios of this murder. The first was, according to the testimony of inmate Hayes, that the defendant had choked Marnie out and taken her for a swim. The second was based on Ms. DaCosta's testimony, that he had tied her to a chair, beat her, and then dumped her in a bottomless pit. And the third was that, according to the medical examiner's testimony, he had fractured her jaw, her head, and eventually threw her into the quarry, which is where her remains were found. Although there are some differences in those stories, and the Commonwealth acknowledges that the defendant left out certain details with regard to each audience he was playing to, the Commonwealth argues that those differences were really a product of the context of each conversation and the specific audience and trying to gain the sympathies of those various audiences. But those scenarios were not mutually exclusive. In fact, each scenario, there are overlapping facts in each scenario. In each scenario, Marnie ended up in a bottomless pit, a body of water, which is precisely where her remains were found. There was nothing in the medical examiner's testimony was unique in this case because it was precisely limited to the remains that were available to him. As my brother acknowledges in his brief and as I detail in mine, there were many bones missing from Marnie's body. The parts of her neck, vertebrae, ribs, particularly the hyoid bone, which was discussed previously, which is the bone that would have been examined typically for evidence of strangulation. So the medical examiner's testimony was confined to what he had. But that doesn't mean, and he never excluded these other possibilities that she was in fact strangled. And in fact, there was evidence. The medical examiner said that she was punched in the jaw, or likely punched in the jaw, on the right side of the jaw, that the fracture to the back of her head was caused by a separate impact, which mirrors the testimony of Ms. DaCosta.
Well, with respect to Ms. DaCosta, though, if I the story, as Mr. Stevenson said, the story included that he sort of abducted her, I'm using that word, from this party, right?
Yes.
But all the other evidence was that she went for a walk and everybody knew she was going to meet him, right, in the middle of the afternoon.
Yes, exactly. However, I think that, and I believe I addressed this in my brief as well, there's some indication that that house party story was actually founded in truth. The very night before Marnie went missing, the defendant discovered her at her own house with a man she was dating, Stephen Bold. And there were other people there. Apparently, Marnie's brother and sister were there, as well as there might have been some other, I don't remember exactly how many. But he went ballistic. He went crazy. He sabotaged Mr. Bold's car. I forget the precise things that he did to the car. But the Commonwealth would argue that that aspect of the story was actually founded in truth, and that the reason he incorporated or partly made up the house party scenario was that he was talking to Ms. DaCosta, who had initiated apparently this conversation by suggesting that if she had the opportunity to kill her estranged husband and not be found out, and get away with it, she would do it. So in that sense, she would be a much more sympathetic audience to the defendant if he could say, yeah, I came upon her with another man, I went ballistic, and this is what I did, rather than I lured her to a field, in which case, after which I, tied her to the chair and perpetuated the attack. So I think that while there are some differences, there are so many similarities, and the jury obviously had the opportunity to evaluate the differences and the credibilities, as any fact finder would have been able to do, or is the job of any fact finder. And they obviously found that the Commonwealth's theory of how this murder happened, and we don't know the precise, we don't know precisely the timeline of the murder, whether or not she was hit in the head and then strangled and et cetera. We don't know the precise, yes.
Help me with one thing. The location of was it the shoes that were found?
Yes, in the culvert.
What's the relationship geographically between where those were found and where her body was found?
Oh, where the body was found in a quarry, which was 10 miles away. The shoes were found in the culvert, which was at the precise, in that field. There's a field in a wooded area in.
Is it on the map?
On the map, exactly, where in between.
So this is not.
Saucer Street.
Okay,
Yeah.
So this is not the quarry. This is just
No,
an
no.
open area.
So
hard to tell from.
And that's an important point to make, I think, because so the Commonwealth's theory was that the defendant lured Marnie to the field. He called her. He admitted he called her around noon on the day that she went missing. She takes her dog. She goes up to the field. The defendant then perpetuates this attack. Now, again, there is evidence, as suggested by Ms. DaCosta, that at some point he took her in a car. When he was acting out the story to Ms. DaCosta, he was, I guess, he mentioned that he was driving her in the car for some point. He had access to a car. According to Mark Roy's testimony, his brother's testimony, the keys were all available to all the siblings. We'd seen that just a week or two before Marnie went missing, the defendant crashed his sister's car when he was apparently trailing Marnie to a local tavern. So we know that it's possible that he'd parked a car up there and somehow, suggested to her, maybe let's go for a ride and talk about whatever he wanted to talk about. And then this attack happened. And yes, the Commonwealth's theory is that he, at some point then, dragged her out of this car and tied her to a chair, which, the Commonwealth had at least attempted to establish that this was a premeditated murder. So according to the Commonwealth's theory, there's no reason that he couldn't have had a chair and any other items that he needed to perpetuate the attack in his car, tied her to a chair, taped her mouth shut, beat her, punched her in the jaw, used some sort of weapon to bash in the back of her head, strangled her, then for a period of time hid her body in this large drainage culvert. The Commonwealth's theory was that at some point, maybe while he was dragging the body over there, the shoes had come off. He left the shoes there, and then at some point, either right after the attack or a little bit later, he came back, likely with a rug, put Marnie's body in the car, covered it with a rug, took her to the quarry and threw her in, after chaining her body to a cinder block.
But it was 2 weeks or so after, the murder was at the beginning of March.
Right.
And there was testimony from his friend
Herman.
with the truck.
Yes,
That
Herman.
it wasn't until later in the month, a couple weeks later, that,
They disposed of the rug.
yeah. So how does that square with what you just said about the rug? And
Well, there's no reason that he couldn't have dumped the body in the quarry and then still had the rug and realized at some point I've got to get rid of this rug, and that's when he'd asked Mr. Herman to go back and to take the rug to the quarry. It's also possible that he didn't cover the body with the rug, but that the rug was somehow used to cover up the murder itself or items used in the murder. Perhaps he wrapped, tape and chain or something like that in that rug to hide it in the house. But in no way is Mr. Herman's testimony in any way inconsistent with the Commonwealth's theory. At no point did the Commonwealth ever argue, and I just want to be very, very clear about this, that the rug was used to hide her body and that what Mr. Herman was actually disposing of when he and the defendant went to the quarry that day was in fact her body. That's never been the Commonwealth's position.
But does it matter that we don't know that the jury may not have been unanimous as to what actually caused the death? In other words, four jurors might have believed beyond a reasonable doubt that she had been strangled to death. 4 jurors might have believed beyond a reasonable doubt that she had been hit once in the back of the head with a rock, and that killed her. And 4 jurors might have believed beyond a reasonable doubt that she had been drowned. How are we to approach that possibility?
Your Honor, I think that especially in a case like this where there are so many possibilities and it's impossible to possibly to narrow down into precisely what happened. And I think the case Nadwarny, I believe is how you pronounce it, speaks to this to a certain extent. As long as the testimony of the medical examiner's testimony was that, even if she was, and he didn't say this in so many words, but even if she was strangled after that, after she was beat in the head, after her skull was fractured, the skull injury alone was enough to cause her death, whether it was in minutes or hours or days, I think he even said.
So all theories may support malice, a finding of second-degree murder, but one blow to the back of the head, does that support extreme atrocity or cruelty?
Absolutely. I would argue that any time there is evidence that a victim is tied to a chair with her mouth taped, unable to move, doesn't matter how many times you hit her, that's extremely atrocious and cruel. And I would also point out, though, that one can't confine one's analysis to merely the testimony of the medical examiner. The medical examiner was presenting part of this factual scenario as to what happened. There was testimony, sufficient testimony from these other 2 witnesses, from Hayes and from DaCosta, that the jury apparently found very credible, that supported the Commonwealth's theory that this had been this one extremely brutal attack. So while, yes, the Commonwealth would argue that certainly a single blow to the head can be extremely atrocious or cruel when taken in the context of the actual scenario, and I think that this Court has absolutely said that a single gunshot can be when it's taken in context, when the victim is made to kneel on his knees and is aware that his life is about to end. This Court has held that can be extremely atrocious or cruel. So it's undoubtable that there's no doubt that the medical examiner's testimony alone could support that. But again, the argument is that the Commonwealth should not be, the evidence should be judged cumulatively as a whole and not simply restricted to one piece of evidence while everything else was rejected. That's not what was before the jury.
There was physical evidence, was there, that consistent with the chair theory?
Yes, there were a couple of things. First of all, obviously the testimony of Ms. DaCosta. Second of all, the victim, Marnie, was bound. I at some point referred to it as hogtied, but I think that that's actually not precise. I think hogtie also has a necktie as well, but her hands were bound and her legs were bound. And in that rope, the rope that was actually recovered in the quarry, there were these extra loops at the bottom of the rope where it would seem that a chair leg probably once was. In addition to that, after DaCosta...
I thought there was something about what remained of her body was in a sitting
position. Exactly. That's why I said hogtied, because that's, to me, what it sounds like, but yes, her body, what remained of her body, which is primarily her lower torso and much of her legs, was in a sitting position. And after DaCosta had made her statements to investigators, they went back and they did another search of the quarry, and they in fact recovered an entire chair and then fragments of a chair near her body.
I thought there was a bunch of chairs in there.
Again, I think it was at least one complete chair, and then there were fragments of another chair or chairs. So again, which is more evidence that supports the fact that the jury likely found Ms. DaCosta's testimony, as well as Mr. Hayes' testimony, as well as the medical examiner's testimony to be credible. And once you look at the Commonwealth's evidence as a whole, it is absolutely clear that the Commonwealth meets its burden of establishing extreme atrocity or cruelty. There was overwhelming evidence of malice. There was the evidence of an unlawful killing. There was overwhelming evidence of malice. And then there was evidence that the Commonwealth could show that that the evidence supported at least 3 of the Kunin factors: indifference to or taking pleasure in the victim's suffering, the consciousness or degree of suffering of the victim, and the disproportion between the means needed to cause death and those that were actually utilized. So with regard to the indifference, there was testimony by DaCosta that Marnie at some point begged to go home. When Kim, Marnie's sister, encountered the defendant a day or 2 days after Marnie went missing and asked her what happened, she asked him what happened. She said that he was indifferent, just said, I don't know, kind of blew her off when Kimmy was visibly, incredibly upset. And the defendant expressed absolutely no regret to any of these people that he told his stories to. Hayes, DaCosta, I think to DaCosta, the only thing that he said that he regretted was that he'd left something behind, which the Commonwealth presumes was the shoes that were found by Kimmy the next day. The consciousness, degree of suffering of the victim, if Marnie was in fact bound and tied and then beaten, she had to have known for some duration of time that her life was in serious jeopardy. And finally, the disproportion used, the medical examiner's testimony was that blow, that fracture to the head alone could have killed Marnie, and yet there was evidence that she was also strangled, also bound. She was attacked by Mr. Roy, who was over 200 pounds. She was barely 5 feet and barely 100 pounds. So it's clear that the Commonwealth establishes extreme atrocity or cruelty in this case. If there are no further questions, the Commonwealth rests on its brief.
Thank you, counsel.
All right.